Hi again. Last topic I'm going to talk to you about briefly is a legal case that we took to the High Court of New Zealand, essentially looking to improve the human rights consistency of the Mental Health Act. And I thought this would be interesting. Obviously, if you're doing law and psychiatry, this seems to be, in some respects, the heart of the matter. And so you know what to expect. I'm going to talk just very briefly about the legal challenge, positionality. You're going to get sick of me talking about it, how things work with time. I think maybe it's useful to understand the background of the sort of people who might come and speak to you about this sort of process, a little bit about the Mental Health Act in New Zealand and the evidence, although one of the concerns the court had was that there was no set of facts and some of the differences in how people understand language, and kind of what the Mental Health Act challenge and what's happened after that means. So in terms of the legal challenge, essentially what happened was myself, Giles and a colleague of mine, Sarah Gordon, who's an associate professor now at Waikato University, and a consumer of mental health services, took a case to the High Court, looking for a more human rights consistent interpretation of the Mental Health Act. All we were asking the court to do was to make statements about making the utilisation of the Mental Health Act more human rights consistent with other legislation in New Zealand. And so that's kind of the drive behind all of this. Heard me talk about positionality, understanding where you come from is important. Psychiatrists, I've had a long interest in both human rights and some of the philosophy of personhood, as well as kind of how we regulate people in society. I trained in England, and when I trained, there were no community treatment orders, for example. And so this is all kind of interesting me when I returned. And it's my colleague, Dr. Associate Professor Gordon, who's, as I've said, a service user academic. So to start all of this off, as a social scientist, essentially, I think the first thing we need to ask ourselves is there a problem? You know, do we need to challenge this problem and do we need to fix it? So I particularly like the work of, I can never pronounce his name rightly, Giles. And I think this is a useful table when we think about clinical research or clinical work is what to do, right? Is there a problem? Is it big enough? What does the evidence say? How confident are we in the evidence, and what do we need to do once we've done this? So what Ioannidis is writing here is about engaging in research or looking to change the clinical environment. And obviously here in New Zealand, I as a psychiatrist had some concern about the way our Mental Health Act seemed to be applied. And so I asked myself these sorts of questions and thought, yes, I do think there's a problem, and yes, I think it's big enough to challenge and or try and fix. And certainly for a long time, my efforts in this regard are focused on research, which was what I was trained to do both in my undergraduate and postgraduate training in medicine. And of course, the thing that we need to bear in mind is that we have this piece of legislation that you're going to be very familiar with that seems to manage, control, dictate to people with this legal thing, mental disorder. Every New Zealander is potentially open to having their well-being come under the Mental Health Act if the process is followed and they're considered to be mentally disordered. And so this is kind of an important piece of legislation. In this context, the thing that kind of amazes me is that this legislation effectively overrides all other legislation. It trumps BORA, and it trumps other legislation and practice designed to protect the human rights of individuals in New Zealand. And what this legislation says is it infers, would be a fair way of putting it. We live in a liberal free democracy, unless you have a mental disorder, in which case you have to do what your responsible clinician says. Now, I think when we think about this, it's important to think about how this came into being back in 1992. And so here I've just taken some readings from Hansard. Um, these are the discussions that occurred in Parliament about the Mental Health Act, right? And so this is a reading from a parliamentarian who was voted in representing Māori. And clearly, as it says, considering the bill before the Mental Health Act was enacted, as he says here, it enables an input to be made from that cultural context to help provide adequate treatment. No complaint here from Māori politicians about the mental health bill. And I guess what Catherine O'Regan does here, and now we've moved on to the second reading here, is make plain what politicians at the time, and this is 30 years ago, considered to be the central dilemma. And as she states, in what circumstances should a civilized society insist on treating a mentally disordered citizen who is incapable of giving consent, or worse still, is capable but refuses to do so? I mean, that is a very interesting statement, and one that would be fascinating to unpack. Certainly, I have no problem with us thinking about managing people who are incapable to give consent. And in fact, all doctors have a duty of care to do that. Although I do struggle with the language about people who are capable of giving consent but refuse to do so, and some of the inferences that makes about mental health patients and their place in society. Nonetheless, the bill progressed, and it was interesting to note that even back here in 1992, there was lobbying concerned about the human rights breaches that this bill may have brought about. So this is prescient, really. I think some of the other human rights concerns that are raised here do indeed and have indeed come about. Although politicians consider this, they clearly considered it to be minor and not a sufficient concern to prevent progress to enactment. And here's a politician you probably remember. So now we're into the third reading, and essentially what we have here is politicians on both sides of the House patting themselves on the back for what they see as a very good piece of legislation. And as Helen Clark, she's the Minister of Health at the time, states, it has bipartisan support, this bill. And I guess that is a good thing, because certainly mental health, mental illness, and legislation surrounding this could be a very divisive task. Curiously, she notes that prejudice is, quote, not unknown or infrequent in this area, but perhaps possibly somewhat ironically fails to notice some of the prejudices inherent in both the Act and some of the readings that are included in Hansard. And Clive Matheson, this is really just showing that these are views from both sides of the House. And as you can see here, there's a clear balancing act in the minds of politicians between right to access treatment, the right to refuse treatment, and the right of society to be free or live civilly, or words to that effect. So politicians pretty happy with the act as it finally occurred. And so, I think it's important that, at least from my perspective, I think politicians back when this act was enacted had their hearts in the right place. They kind of wanted to avoid, as it says in some parts of Hansard, the passions of the people. They wanted to protect the public, although that does say some interesting things about mental disorder. But we're also clearly trying to think about providing rights and access for treatment. So it is worth bearing in mind that there were difficulties with access to care. There was concern about the so-called revolving door of mental health patients in and out of hospital. Deinstitutionalization was just finishing off. And so kind of a lot of people who had spent a long time living essentially in asylum care were now in the community. There were concerns about whether they'd simply be dumped in the community and would get no care where they'd had asylum-based care before. So I don't think this was about trying to bang people up or take away people's rights. I think politicians were thinking hard about protecting mostly patients. And it's interesting to see that this is their conceptualization as opposed to how the utility of the Act actually played out. And that's the bit we need to think about. And we'll just whiz through this very briefly. We've talked about this before. Um, so what this slide from a paper of Anthony O'Brien, Associate Professor up in Waikato, nurse, academic, shows us here is that we use lots of mental health legislation. So as the little red square box shows us, we're world beaters almost in the use of Mental Health Act. This rate continues to climb and is sort of settled on or around about 100 per 100,000, and that rate's considerably higher, over 400 per 100,000 for Māori men. So we use the Mental Health Act a lot, and a lot of people are detained. And we use the Mental Health Act in a way which doesn't show consistency by region. So some places use heaps, other places you use less. And when you cut this by ethnicity, gender, or age, these sort of disparities get even worse. So although the Act is, in its conception, designed to support people with mental disorder, it's been used in a kind of a weird and wild way and used a lot throughout New Zealand. I do not think the politicians of the 1990s would have expected these rates or this degree of variability in use. So this slide here comes from the reports from the Director of Mental Health Services and just shows us how much these various parts of the Act are used to detain people and how much more they are used to detain Māori compared to non-Māori. So I guess all of this information concerned me, and all of this information made me feel like we needed to do something. And it's important to notice I started thinking about and doing work in this area back in 2008 when I returned to New Zealand. And certainly, as you'll see if you read the reports from the Director General of Mental Health, there's been no improvement. Despite doing lots of research and publishing lots of papers, writing in the conversation and for the press and other places, nothing changed, which of course raised the question for me, can we do something through the courts? When the courts make an order, people have to follow it. So was there another way of doing this? And so in the back of my mind, I was sort of thinking about this. And while I was thinking about this, what I wanted to do was collect what I thought was evidence to provide to the court, not realizing that court considered evidence to be a set of facts from a single individual, and a very different way of understanding the concept of facts. And so what I've done here is just given you a little taste of some of the evidence which is out there, science evidence. So the Octet trial is a very, very large randomized control trial, the highest order of evidence purportedly in science. And essentially what that finds is that community treatment orders in this case make no difference to outcome, i.e. they're not worth it. The Cochrane Library is a library of systematic reviews, so an even higher level of evidence than randomized controlled trials. And what the Cochrane Library review, and again we're looking at CTOs here, would suggest when they review it is it makes no difference. CTOs. The final paper down here, and there are a few papers like this, take a much looser approach to papers. They're not so rigid. The idea here being that they want to get a kind of a broad view. What does the evidence tell us, both in terms of what it's like in real life, as well as in these sort of slightly contrived randomized control trials? And these sorts of systematic reviews also suggest that really there's very little obvious benefit from mental health legislation, essentially no matter how you look at it. It's not quite that cut and dry, but that's essentially what these randomized control trials and reviews of them suggest. So high quality, 3 randomized control trials, a bunch of people, maybe not very many, but enough that we sometimes prescribe scary cancer drugs on studies with about this number of people, but they suggest it doesn't really help. Now, each of these randomized control trials is open to criticism, and criticisms have been made of them. And I guess that's the reason in the last slide for showing you other approaches to the evidence, which are also essentially negative. So what does that mean? Well, the sciencey evidence suggests they don't make any difference. So you can ask the question, why do psychiatrists use it if the evidence doesn't say it would make any difference? But there are a variety of legal and social reasons why we might need to do that. And that also raises the question of economics. How expensive are they? It's actually incredibly difficult to do these, basically because the science suggests they're negative. And so that would suggest that the cost effectiveness is going to be infinite because they're not effective. Looking at some of the secondary outcomes, you can end up with an ICR's incremental cost effectiveness ratio of something like $4 million per quality adjusted life year gained. And this is super low. So to put that into perspective, most of the drugs that get funded are probably 100 times better than this in terms of their cost effectiveness. So if this is looking at CTOs rather than all of mental health legislation, which is essentially impossible, but using this sort of logic, Pharmac certainly wouldn't be keen to fund our CTOs out of our restricted budget. So we've got some science that suggests it's not a good idea. We've got some economics here that suggest it's not a good idea. And we have some qualitative research. So this is qualitative research done here in New Zealand. And essentially what this qualitative research shows us is that most mental health patients feel dehumanized, feel as if they lose their dignity or get coerced by mental health legislation. There is a small undercurrent suggesting it does things like helps to protect people, but certainly, and helps to access care, but certainly qualitative research does not support mental health legislation in a way that might counterbalance the sort of negative effectiveness from quantitative findings. So we're back to thinking about the legal challenge, right? The science says don't do it, the ethics say don't do it, the economics say don't do it, qualitative research says don't do it, but we keep doing it. And I guess my sort of frustration, I suppose, at this, my discomfort about the way we were expected to practice here in New Zealand, led to this idea of bringing a legal challenge. Now, what I'm not going to do is talk you through this in minute detail. In fact, I don't think I'm qualified to do that. That requires a lawyer, ideally an academic lawyer who understands the case well. What I do want to do is give you my reflections on this process. It took a long time to get to the point where we could bring this case. So firstly, I needed to find somebody who could act for me in a way that wasn't going to cost me money I didn't have. And I guess it's important to notice that. So this could not have happened without Iris, who took the case on a pro bono basis. It also became pretty clear that I wouldn't be considered to have standing without support. And Sarah, my colleague, was considered to have standing too as a direct mental health consumer. My personal view is we are all potentially open to being detained. But again, it shows the difference between what might be considered a kind of the man on the Clapham bus perspective and the perspective at law. The process of filing paperwork to being heard took about a year, and the process from the 2-day hearing to the finding being released was about another 6 months. So it was another learning for me, was that this was a long process. And in this particular area, that makes a difference, partly because people are continuously being detained, but also it's an area where there is some shift from a Parliament perspective around mental health legislation. And so what we suggested to the court was simply that they make mental health legislation compliant, essentially, with BORA and other legislation we had. I don't think any of this looks controversial. We said if you've got decision-making skills or mental capacity, we should respect it. All right? If you're subject to compulsory treatment, then when you have the capacity to consent, we should respect your consent. That if you're a young person and able to give valid consent, we should respect your consent. If we've made a legally binding, a valid advance directive, it should be legally binding and we should follow it. And the last thing we asked the court to do was simply make a declaration stating that there was poor evidence in regard to the use of community treatment orders. None of this looked to me, as a lay person from a legal perspective, like people really asking for much. And certainly, I was not expecting cost, time, or the 75-ish pages of findings from Justice Cull. But that's what occurred. And what did Justice Cull say? Declined all of the applications made, and so the whole thing came to nothing. From that point, we considered an appeal, and in fact started down the process of lodging an appeal. In the first case, we had approved a protective costs order, and I'm not sure that first case would have gone ahead without it. For the risk of many tens of thousands of dollars of costs, even if they fall equally, and our lawyer being pro bono. And that really is a considerable risk if we'd had costs awarded against us. I hate to think at the sort of potential cost it could have brought. And for that reason, this wouldn't have worked without that protective costs order. And in fact, at the Court of Appeal stage, the protective costs order was declined. And after discussion with Sarah and taking advice, we decided to withdraw the appeal. And so this is now completed. And it would be great to talk about this, but you're going to need to ask somebody who's cleverer at law than me, and you can go and read Justice Cull's finding and reasoning here. I'd encourage you to do that. And so what do I make of all of this? Well, the first thing I make of this is taken up an awful lot of my adult life. It's been on my mind a lot. I've invested a lot of my career in research into this. I've invested a lot of my personal time into this, both in terms of this particular case, but also some of the reading around it. I guess my second reflection is it just didn't seem like it really was asking for much. I wasn't asking for mental health patients to be special. In fact, I was asking for exactly the opposite. We just wanted mental health patients to be the same as everyone else, but that seemed to be a bar too high. And I guess the third point, and this is extremely relevant, I think, in a class like this, actually, but for anyone doing law, is I had no concept of how much time and subsequently how much money all of this was going to take. And when I reflect this, my reflections are, would have the time and money, that would have the time spent by my pro bono lawyer, clearly who has a very strong regard for human rights and health in New Zealand, would have her time be much better spent somewhere else, making a real difference, because I'm not sure this has made one. And we consumed a not insignificant proportion of time from the Human Rights Commission and, of course, the Ministry of Health. And so it weighs on my mind the not insignificant chunk of money, public money, now taxpayer money that we've consumed for something that went nowhere. And it does. I reflect on that and how that might impact on what I do in the future, but also how you might think about a case like this. I guess another reflection is, even with all of that costs that we did not personally bear, there were potentials along the way here for this to be extremely risky from a financial perspective. As the case turned out, those risks were mitigated a great deal, mostly by the excellent work of our lawyer. However, it's difficult to see how cases like this come to court where there's no gain for me in this. I'm not detained under the Mental Health Act, and never have been. Trust me, my work is not going to get lighter if they'd agreed to this. If anything, it probably would have got more from a clinical perspective. But still, there was quite a lot of potential for risk. I think I was interested to notice how regularly this case confused me prior to the workup in itself, and in reading and rereading the decision of Justice Cull. I did a fourth-year law and medicine paper a million years ago when I was doing my medicine degree. I regularly read case law. Obviously, I'm an academic. I do qualitative and quantitative research and have a number of degrees, including a PhD. But this just confused me. It was difficult to follow at times. And at times it was just, I felt at sea. We go to court regularly when patients are detained under the Mental Health Act. So I'm used to going to court. I'm used to being in front of a judge. And still I found this process difficult. And so for those of you who end up becoming lawyers and mental health lawyers, it's an interesting thing to notice and reflect on the relative lack of power, that the lack of knowledge your clients have in most situations. And so look, I'd encourage you all to go and have a read of this. I'd be very happy to answer questions if people have them about this. And hopefully this has been helpful for your learning.